Thank you for joining us today. We've got a great topic here. We're focusing on the U.S. Supreme Court rulings and cases and how they can or may impact the stormwater sector moving forward. My name is Seth Brown. I'm the Executive Director for the National Municipal Stormwater Alliance, and we are the one hosting this event today. So thank you for joining us for this event. Dave, can you go to the next slide? And Dave Smith is facilitating today, and we've got three speakers: Sean Haggerty, Jeff Longsworth, and Fred Andes. We'll do a more formal introduction for everyone. And just to provide some context on the National Municipal Stormwater Alliance, we are a national organization that focuses solely on the MS4 sector. We've got our members are organizations, state organizations that represent MS4s or MS4s themselves, or other organizations that are associated with the MS4 sector or have some kind of tie there. We were formed in 2016. We officially became a 501c3 in 2018. And our focus is really, our motivation is to help mature the stormwater sector, the MS4 sector, try to provide more of a unified voice for a sector that is in many ways disparate. So we're trying to push things forward that way, increase the view of stormwater as a resource, and just get more coverage of stormwater in general. And our vision is very simple. We want to help create more, help get more clean water for the sector. If you can go to the next couple of slides, Dave. And then the next slide, please. Our action areas are listed there. Our primary mission is to support MS4s in the MS4 sector, but we also focus on messaging and communication, because that's such a big proponent or component of our sector. Of course, as a 501c3, we disseminate technical information, and we also are engaged in policy and advocacy, and that's what we're going to be focusing on today. So this fits into that category. Next slide, please, Dave. Just so everyone knows where we're coming from as an organization, we represent 26 state groups across the country. That's approximately 4,400 total MS4s, or over half of the regulated urban population. We're starting to get MS4s that are joining us directly, so we've got over 30 MS4s now, and we have other affiliate members, law firms, consultants, technologists, and whatnot. If anyone's interested in learning more about joining, there's the information there. There's a link there and a QR code. These slides are available in a PDF format in the handout section of your GoToWebinar app, so you can download this at any time. So that information is available. A couple of things that we're doing in the next slide, please, Dave. A couple things that we're doing, or the next big thing that we're doing in the policy area is the National Stormwater Policy Forum. We've been doing this. We work with the Water Environment Federation, the National League of Cities, the National Association of Counties. We have panels with folks. Some of the folks here today are going to be involved with that, or attending at least. And we'll be focusing on legislation, regulations, policy, and any other kind of hot topics. And we always record those and post that to our YouTube channel. You can engage for free. Can you go to the next slide, please, Dave? We can engage for free either way. If you want to go enjoy or engage virtually or engage in person. It's April 7th from 12 to 5 p.m. That's Eastern time. Sorry, I didn't clarify that. That's Eastern time here in the Washington, D.C. area. So there's a link there, and again, that's available also in the PDF that's in the handouts area. And one more slide, Dave. Just for housekeeping purposes, just want everyone to know that this event is being recorded. Like I said, these slides are available in PDF format there. If you can't get to that, you can always contact us, and there will be contact information at the end of this. There's 1.5 PDHs available. You will receive a certificate as an attendee here. If you've got questions, we encourage questions. Please type them in the questions portal. In the chat area, please put any kind of technological issues that we'll address at that point in time. So I think that's it, Dave. I just wanted to kick things off and get the housekeeping out of the way. So I'll kick it off to you.
Well, thank you, Seth. And hello, everyone. Thank you for joining us. I'm Dave Smith, and I'm a water policy consultant with Water Innovation Services. Spent most of my career working on stormwater and other things at the U.S. Environmental Protection Agency. But I'm really thrilled to be joined today by three real experts in environmental law and know a lot about the stormwater sector. Jeff Longsworth is partner at Earth and Water Law in Washington, D.C. Fred Andes is a partner with Barnes and Thornburg in Chicago. And Sean Haggerty is a partner with Best and Krieger in San Diego, California. So thank you, gentlemen, for joining us here. I'd also like to thank Tess Dunham from Con, Suarez, and Conway, who hosted a similar session to this at a recent California stormwater conference. And she kind of helped frame these issues and questions real well at that and kind of motivated us to get this organized kind of at a national level. So as you probably know, there are several recent Supreme Court cases that have significant potential implications for stormwater permitting and management. And today we want to explore those implications in some detail with our esteemed panel. We're going to briefly describe some of these key cases that we think might affect stormwater regulation in the future. And we're going to ask some questions to help us consider how those cases individually and collectively might affect stormwater management. I've divided these cases into two broad categories. Kind of administrative oversight cases and how the judiciary, oversees rules and permitting, and we'll briefly describe these cases. The second category is ones that focus more on the substance of regulations or permits, and there's several potentially relevant cases there. And I think that should keep us pretty busy during our time today. However, you might be aware that there was a recent election. And we're also, as time allows, going to ask our panelists to apply their crystal balls to talk a little bit about what they expect in the way of new administration priorities that may affect stormwater management and regulation. And so hopefully we'll kind of tie all these things together as we go through our time. And I do encourage you to submit your questions, and we'll get to those as time allows. So first, before I bring in the panel, I want to briefly summarize each of these administrative law cases because we're not assuming that you have great familiarity with each of those. First is the Loper Bright versus Raimondo case. This case addresses the question of how much deference courts should give to agency interpretations of law when a statute is silent or ambiguous on a particular provision and its meaning. This case concerned a National Marine Fisheries Service rule concerning that required fishing companies to pay for the costs of federal monitors on fishing boats. Previously, under the Chevron v. NRDC decision, agency interpretations received a high degree of deference in judicial review and proceedings. Through the Loper decision, SCOTUS firmly ended Chevron deference to agency interpretation and assigned principal responsibility for interpreting congressional intent to federal courts, a result that could make it more difficult for agencies to adopt and defend environmental rules. Next is the Corner Post case, Corner Post versus the Board of Governors of the Federal Reserve System. And this case addressed the question of how long parties have to challenge a federal regulation after it's adopted. This case concerned a dispute over fees for credit card transactions in which Corner Post started a business long after the rule in question was adopted. And they asserted that they should be able to challenge the underlying rule governing credit card transactions that was at issue here. Previously, in most cases, parties had a specified period, often 6 years, from the date of rule adoption to challenge a rulemaking. The court found that the time window to challenge regulations actually should start at the time that a party is injured by that rulemaking, or they allege that they are injured by it. And so in essence, it gave Corner Post the opportunity to challenge the underlying rule, even though it was way after 6 years. That decision could enable some parties to challenge EPA rulemakings that were done many, many years ago. They were previously time barred from challenging them, but maybe now they can. Next is the Securities and Exchange Commission versus JARCASI. And this case concerned a securities fraud allegation where the Securities and Exchange Commission brought a case before an in-house administrative law judge. Many federal statutes, including many environmental laws, authorize the use of administrative law judges or ALJs to hear and decide enforcement cases that are separate from the regular federal courts. The key question in JARCASI was whether a defendant is entitled to a jury trial in these proceedings. The court found that defendants are entitled to jury trials in this type of case, and that outcome could affect it could affect the ability of defendants to prevail in enforcement proceedings before ALJs in EPA enforcement cases. And the final one in this group that I'm going to mention is not yet before the Supreme Court. It's Port of Tacoma versus Puget Soundkeeper Alliance. And a cert petition has been filed with the Supreme Court, hasn't been accepted, but it's been the subject of many filings on whether the court should take the case over the last few months. The case concerns a challenge by an environmental group to a state-issued NPDES stormwater permit. And the case considers the question of whether a citizen suit challenging that permit can challenge in federal court provisions in that permit that were incorporated based on state law that are more stringent than federal requirements. The Ninth Circuit ruled that the plaintiffs could challenge permit provisions incorporated under state law, in this case brought before a federal court. And that decision kind of contrasts with an earlier Second Circuit decision. If the Supreme Court accepts this case and sides with the Ninth Circuit, it could enable litigants to challenge permit provisions based solely on state law requirements, but in federal court. So those are the main cases that we're going to talk about in this section. So Fred, I'm going to start with you and ask you, how might the Loper Bright decision affect how judicial review of stormwater permits and the underlying rules proceed?
Sure, Dave, thank you. Well, I think that it will affect some situations and not others. Some people, you sort of get some headlines about this, like eliminating any deference to agencies, and that's not really the case. There are really two sets of scenarios in which you're challenging agencies. One is, in some cases, you're challenging them because you think they acted outside of their legal authority, especially in situations where they've issued new rules or new interpretations of rules, and you're saying they just don't have the authority that they've assumed. And Loper Bright will affect those cases because in those kinds of situations, what the court in essence said is, normally under Chevron, in situations where there's like some ambiguous statutory language, and there's a lot of ambiguous statutory language, and the agency is saying, well, we're interpreting the ambiguous language a certain way to create some new regulations, say, the court would generally defer to the agency and say, look, we could go a few different ways on this, but we'll defer to the agency as long as their interpretation isn't crazy, really. Doesn't have to be the best interpretation, but it's not insane. So we'll go with what the agency says. And that's what the court clearly struck down and said, no, when you're interpreting statutory language, the courts have the final authority, and we don't want you to defer to the agency in interpreting ambiguous statutory language. You make up your own minds, judges, and as to what the best interpretation is of that language. So this is coming up, for example, on drinking water standards for PFAS and whether EPA can use a hazard index to form a standard. And there's a real legal issue there about, well, is that within their legal authority? They've never done it before. And to me, in that kind of situation, Loper Bright says the judges make up their own minds and they don't defer to the agency. On the other hand, where you're challenging an agency because they're arbitrary and capricious, because you think they've made terrible scientific decisions. They've written the rule. It's not that they don't have authority, but they've done things that just don't make any sense. In those situations, Loper Bright doesn't really affect that. There still will be some degree of deference to courts, by courts to agencies in those cases where the agency is acting within its expertise area. It's not interpreting as legal authority, but rather it's saying, well, we're looking at all the science or lack thereof, and we're making some calls. And in those cases, I think it's still, Loper Bright's not really going to affect that. Now, some courts still are taking a skeptical air even in those areas lately, but it's not because of Loper Bright. Loper Bright will affect more situations where you're arguing the agency's acting outside of its authority, the authority is ambiguous, and the court, in essence, now will say, we're not going to defer to the agency, we're going to make up our own minds. So it definitely gives you more opportunity to get an agency decision struck down if you're arguing that they are outside of their legal authority.
Thanks, Fred. Hey, Sean, Jeff, would you like to add anything?
I'll build on Fred's, I think, in the next question, but nothing to add right now.
Okay. Well, then I'm going to jump to that and ask you, Sean, how might this decision affect how EPA writes or revises its rules for stormwater permitting in the future?
Great, Dave. And I think this will build on what Fred just said, because I think the distinction that Fred just made is really critical here. And let me start by, I'm going to answer this from a perspective of what I'll call like a generic EPA. I think let's put aside the current administration for right now, but from sort of more of a historical perspective of how EPA has traditionally written rules. I do think it will have an impact and make it more difficult to write and revise rules in the area that Fred just articulated, where the EPA is either pushing the boundaries of its authority, or that there is an open question of what its authority is. So when it's really dealing with questions about the law and trying to interpret the law, it's going to be more difficult to write rules in that context. I'm not sure that that's necessarily a bad thing, because a lot of the current rules dealing with that subjects are almost more like briefs than rules, and you know, they're pages and pages of trying to interpret various court decisions, and a lot less in the area that Fred said, you know, where there should remain deference, which is bringing their expertise and bringing the science to the question. So I do think in that world where there are these unanswered legal questions, it's going to be much more difficult to write rules. And I think in that sense, in general, there will be fewer rules written in that context. And I think the courts are going to have to give more guidance, and then rules will have to follow from that guidance, because the case very specifically says courts interpret the law, you don't interpret the law, EPA. But Fred is 100% right that it should encourage EPA to focus more on where its expertise is and bring that to the table. And writing rules in that context, I think, you know, there should be some level of consideration of EPA's interpretation and position on the science and the facts, and you know what needs to happen to sort of forward the policy goals of the Clean Water Act. So in the end, I think that in general, it's going to force more focus where I think the focus should actually be, which is, you know, on the expertise and the science, and less on, you know, EPA basically being a law firm and trying to write briefs. Well, now with the current administration, I'm not sure it's going to have that great of effect, because I'm not sure how many new rules or we're going to be anticipating in the stormwater world here in the next little bit. and certainly not ones that would push the legal envelope. So I'm not sure that'll have an effect. I guess there's an outside chance that it's reversed a little bit. And to the extent that there are decisions made that are limiting or EPA is not acting in certain areas where maybe the law requires them to, conceivably it could come into play a little bit there. But I think that for the most part, we're going to see significant but longer term implications over longer periods of time than the current administration. And I do think that that will be a pullback from some of the rule writing that really is more about extending the law than about factual analysis and scientific expertise.
Great, thanks, Sean. Well, Jeff, I'm going to actually, anything to add, Jeff?
Just say that I think, it's a long-term thing, but I think that part of the intent of the Supreme Court was to actually get Congress to write better laws. A lot of times in Congress, when there are controversial issues and they're going to, try to resolve those through conference between the House and Senate, whatever the case may be, they tend to kind of water down some of the language, and that's kind of created this whole situation. And I think the Supreme Court would like to see Congress pass more clear laws, which then gives EPA specific authority. But I agree with both Sean and Fred. In the interim, there are going to be some challenges.
And it will be interesting to see how this plays out in the stormwater world, since Clean Water Act 402P is maybe not a model of clarity. We shall see. But Jeff, I'll ask you a follow-up. Do you think this decision creates an opening to reconsider the Defenders of Wildlife versus Browner decision that recognized the discretionary authority of permitting authorities to incorporate numeric water quality-based provisions in stormwater permits?
So first of all, thanks, Seth, for inviting me, and thanks, Dave, for organizing this. I guess I'll start out to answer that question with the 600-pound gorilla in the room on that question, and that is, back in the 1990s when they were writing the stormwater rules and regulations, one of the things they didn't do that they should have done was develop wet weather water quality standards, because what we're really talking about are ambient and acute, and chronic water quality standards, which are designed to protect waters in a low flow 24/7 condition, which is not what stormwater is. So, at some point, maybe we'll go down that path, but that's ever since we don't have those wet weather water quality standards, we try to keep putting the square peg in the round hole and figuring out how we apply these things. Specifically to your question, the Defenders of Wildlife case really was a Chevron step 1 case. The court found that in fact the statute was clear that Congress intended for EPA to treat municipal stormwater discharges differently than industrial stormwater discharges. And so that provided EPA with the flexibility to determine exactly what they need to do. The kind of the discretion comes in the part of the statute that says that the permits for discharges from municipal stormwater sewers shall require such provisions as the administrator determines appropriate for the control of such pollutants. That is an area where that gives obviously significant discretion to the administrator to determine how far they need to push beyond just technology-based requirements for municipal permits. So I don't think Loper Bright really affects this case directly in that regard, but it does help to point out, kind of there can be, I think, both statutory discretion specifically granted, as here, versus agency discretion to interpret a completely unclear statute, which is really the issue that Loper Bright is getting at. So again, we're going to continue to have all of these debates and arguments in part because we're trying to apply water quality standards that were designed for one thing to a situation that is something different.
Thanks, Jeff. And we'll probably get into this issue a little bit more in a little while when we talk about the recent San Francisco case. I'm going to turn for a minute to the Jarkissi case, which is the one that talked about your statute of limitations on challenging rules. Sean, I'll ask you, excuse me, I got ahead of myself. I want to talk first about Corner Post, which is the case that concerned statute of limitations for challenging rules. Do you think that decision increased the likelihood of more challenges to longstanding rules implementing stormwater permitting? And if so, what do you think those challenges might look like?
Who are you asking?
I'll direct that to you, Fred.
Okay.
Thank you.
Yes, it could, but there's some caveats there. The Corner Post was, not an environmental case, but it was about the overall concept of, like, when does the general 6-year statute of limitations for review of agency actions start applying? And in essence, it said that it doesn't start, the 6 years doesn't start until you've suffered an actual injury. So if you had a facility that didn't exist when the initial rules were issued, but you just built the facility now, in essence, the court was saying you have 6 years from now to challenge that rule. So if you've been regulated, if you have an existing facility and you've been subject to these regulations for years, you can't really, Corner Post doesn't help you come in now and say, oh, I want my 6 years to start now. Like, well, wait a minute, your injury happened 20 years ago, and you can't complain now. But if you have a situation where, there's a new system that is only, or a system that was not regulated before and now, say, has gotten big enough that it will be regulated, then there's the possibility of starting that clock now. So, those who might want to challenge a rule would need to come up with those types of factual situations where somebody's just now starting to be covered by the rules, either because they changed their status or because they just built the system. The other issue is under the Clean Water Act, it's got sort of a hybrid or system of some rules have to go to the Court of Appeals within 120 days, and some rules don't. And if you have a rule that had to go to the Court of Appeals within 120 days, Corner Post doesn't really help you because that 120 days is in the statute, this statute. Now, though years ago, somebody tried to challenge that whole system and say, well, is that even constitutional? There's an Adamo case from years and years ago where Supreme Court started, you and I talked about this before, the Supreme Court started thinking about that issue a number of years ago, like, can you really tell people 120 days period when their facility may not exist within 120 days? That's a really interesting issue, and maybe the court will go there eventually and knock down some of these deadlines in all the statutes when the statute's really clear about certain deadlines. But Corner Post by itself doesn't do that. Corner Post only deals with situations where there's no operative deadline in the statute, and there are some decisions under the Clean Water Act that aren't that don't have the 120 days, and where you might argue, particularly say if you have a system that changed status and is newly regulated, that you might want to, you might be able to try to challenge the regulations, say, look, they just apply to me now, and I want an opportunity to challenge it. You'd have to then think in terms of, well, what are your legal claims, and will they be ones that have deference or not deference? But it does open a window, although it's not quite, again, it's not quite like some of the press reports were like, oh, they've done away with statutory deadlines for challenging actions. Well, no, you still got to show that the injury is only occurring now or within the last 6 years, and therefore I can raise a challenge to a rule that's old.
And I'll note, I have heard more people talking about this potentially impacting industrial stormwater discharges because there aren't going to be that many new municipalities starting up the stormwater business, but there might be industries that do.
There are also, I mean, some situations I think I've talked about with Seth where the system may be below the level of regulation, then come into the regulations because it expanded. And that might be a situation that could be covered.
Sure. Jeff, Sean, anything you want to add there before we turn to a different case? Maybe not. Okay, then we are now going to turn to jarcossy, which talked about jury trials and administrative proceedings. Do you think that that decision is likely to create any meaningful changes in how administrative law cases are litigated and decided before administrative law courts?
Yeah, Dave, I'm trying to get my head around exactly what the implications of this will be. And I'd love to hear from Jeff and Fred too on this question. I mean, in my practice, which is primarily in California, when I'm not dealing with a citizen suit case, it's 100% administrative enforcement. And so how, you know, if there's a Seventh Amendment right to jury trial in that process, it will fundamentally change, it could fundamentally change how that process, you know, moves forward. And if that right exists at the administrative level, it's going to make administrative enforcement significantly more complex and significantly more costly, which will, by definition, mean there'll be fewer cases brought, and maybe there'll need to be much more significant strategic decision making on what cases are enforced and what aren't. But you know, how this ripples through all of the different enforcement processes at all the different levels of enforcement that occur, I really don't fully, you know, haven't really wrapped my head around that. But certainly, if you know, if every enforcement action could result in a administrative jury type trial, you're going to have a lot less enforcement, and it's going to be much more costly. And you know, I think there's also going to be a lot less certainty in results in enforcement. I mean, for better or for worse, you kind of know where things will play out, you know, generally in an enforcement case based upon sort of your experience and the different entities you're before, and you can give a pretty clear range of where you're going to end up and where settlement will occur. But yeah, I mean, if you're throwing everything to a jury, who knows? So again, this is one, Dave, I'll ask the question to Jeff and Fred, if you know how they've thought about this and how they think it might ripple through the system.
Well, I mean, I'd just say that first of all, I'm predominantly an administrative law side of things in Washington, D.C. here, you know, working on stormwater rulemakings and challenging effluent guidelines and other things along those lines, or defending EPA in terms of effluent guidelines, which we've done also. So I don't do as much enforcement, and I guess I'm blessed in that the enforcement cases I've had, I've been able to bring to settlement pretty quickly. So I don't do a lot of work in front of the ALJ, but it's an interesting issue that I've followed, and that the SEC case is a very interesting one and trying to contemplate. But I agree with you, Sean. I think there's a lot to play out here in terms of what authority EPA still has within the ALJ process, and what rules it can or can't write in that regard. Based on, again, Loper, you know, all these things start to overlap a little bit, but those are the kind of interesting kind of intellectual things that I look at.
Yeah, I think that from the enforcement standpoint, EPA administrative proceedings that we've experienced certainly lately are rarely involving penalties. And when they do have penalties, they're usually pretty minor. So usually not worth, you know, contesting on their own. But we have had some cases where states will proceed administratively instead of judicially, and sometimes those penalties can be pretty significant. And that to me is where like if jarcossy extends from a constitutional perspective and right to trial by jury to those state cases, then I think there are cases where the states proceed, like Sean is describing, administratively instead of going to court. And sometimes the penalties are pretty significant. If this affects those situations, I think they're really going to have to contemplate, do they take those all the way to court? Or will they file less of those? Or in some cases where if the main issue is compliance, would they proceed, say, without a penalty? And to get those resolved, because if they put in a penalty, we're going to be, fighting that in court, and they might not want to do that.
Yeah, Fred, I totally agree that I think that's where the real action is going to be, is how far this extends to state enforcement in the, the federalist world that we live in here. And it's 7th Amendment to the Constitution, so it's got to apply. So we'll see how that plays out. But you're right that my state level enforcement, we're talking millions of dollars in terms of penalties, right? So there may be many parties who say, if you're going to pursue me for that, I want to have my day in court and be in front of a jury, and that will be interesting to see how that all plays out.
I want to get to one or two questions from the audience. Thank you for those. First question is back to Corner Post. Is there anything to close what seems to be a loophole for existing entities to just start a new business doing the same thing in order to start their 6 years from scratch and challenge regulations that they were previously subject to under a different name?
Oh, I think courts are usually pretty good at spotting subterfuge. And I think if that's all you're doing, then I think generally courts would see through that.
Yeah. Okay, I'm going to turn, before I ask this next question, think about backsliding. I'm going to get to a backsliding question in a minute. But I wanted to spend a minute on the Tacoma versus Puget Soundkeeper case. And Jeff, I'll start with you here. If the court accepts this case, how would you venture to guess that the Supreme Court might rule? And are they likely to uphold the right of a citizen group to challenge permit provisions adopted under state law? And would that matter?
I think that this case raises a lot of federalism issues, a lot of kind of the separation of powers, and we have a federal Clean Water Act that has certain demands and mandates in it. And then states also can develop their own Clean Water Acts as long as they're consistent with the federal statute. And many states like Washington, California add additional provisions in there. So I think this kind of end run to try to enforce a state provision through a federal court is not going to be, I don't think it's going to be successful. I think that particularly this Supreme Court is going to look at the statutory language of the Clean Water Act and determine whether in fact the provisions that are trying to be enforced are covered by the federal Clean Water Act or not. Now, the Puget Sound Alliance attempts to make the argument that, well, if you look at Clean Water Act Section 402P section or P2E, that it gives the administrator or the state running the stormwater program residual designation authority to identify particular sources of pollution that would not otherwise be regulated and then bring them into that regulation. But I think that argument fails because what it does is it brings them into regulation, again, under the federal Clean Water Act, not under additional state provisions. So I do think that this is a case that the court will take, and that we will have a little bit more separation of federal versus state power, which is partly what happened in Sackett, which we'll talk about, and some of the other Supreme Court cases. So I look at it more consistently with Supreme Court looking specifically at what the Clean Water Act says and whether it covers the types of provisions that are being challenged by the environmental groups.
Sean, Fred, care to add anything?
Yeah, Dave, I'm incredibly intrigued by this case. I think, as you may know, I've done a lot, 20 years of my career has been on the question of unfunded state mandates. It's specific to California, but it's fundamentally this question of, you know, where federal law stops and where state law picks up when you have an authorized state issuing NPDES permits. It's this. I really hope the court takes this case. You know, at least at the California level, we have a state Supreme Court case and multiple Court of Appeals cases now saying that yes, there is a limit to what is mandated by federal law, and then the states can pick up from that. And when they do that, even back to the question about you know, defenders, even when they're using their discretion, where they have discretion under federal law to go beyond, they're doing that under state law. At least that's what the California decisions say. So I think that line of cases is really interesting, and it's going to hopefully tie into if the Supreme Court takes this case. But then you have cases like the NRDC case, which, you know, there was clarity from the Supreme Court, and it went back to the Ninth Circuit, and the Ninth Circuit basically decided that case ultimately on really contract terms that were basically about state law. So there's a lot to sort of square here between the unfunded mandates questions, previous decisions like NRDC, defenders, and this case could really help clarify a lot of that.
Sure, Fred?
Sure. The other side of this is states, and we have a bunch that we practice in, where they're not allowed to go beyond federal law. And the question then becomes, well, if federal laws are changing and getting more restrictive, or federal interpretations of federal laws are getting more restrictive and narrower, how does that affect the state rules and state permits? And does the state then need to reassess whether they are acting beyond federal law? Because they may have, you know, fashioned the rule that fit very precisely where the EPA interpretations were, but if those interpretations change, then challenges and say, hey, under state law, you are not allowed to have a broader permit than the federal regulations and interpretations. And now those have narrowed, so you need to narrow what you do.
Excellent, thanks. So I'm going to go ahead and raise this question now. We could raise it later, but a good question from the audience is concerns backsliding. And I think they ask it this way: how could these rules, and I think they mean, you know, these changes in interpretations of rules and permitting approaches, be impacted by the existence of the anti-backsliding clause in the permit regulations, and whether and how that applies in maybe changing or relaxing the terms of stormwater permits? Anybody care to venture a thought on that?
I mean, I would say that, first of all, there's, you know, the people that know the backsliding, there's kind of the statutory backsliding provisions, and then there are regulatory backsliding provisions. And again, going back to Loper, one would have to question whether all of the regulatory backsliding provisions are applicable. But there are exceptions to the backsliding rule in terms of new laws, new you know, economic issues, a whole variety of things that can justify you know, a backsliding, and again, it applies generally to numeric effluent limits, and we see fewer of them in stormwater permits than we do in other permits. But it's an excellent question, and it's one that comes up every time you try to make a modification to a stormwater permit, either by the regulators or by the local community groups or whatever the case may be. So you always have to be well armed on backsliding arguments going into any kind of regulatory permitting action. So I'm not surprised to see the question come up again here.
Yeah, I agree with Jeff, and I think that whether you'll be able to get the permit changed will depend to some extent on Was it being changed because the agency decided certain things were outside of its legal authority? In which case, that'd be easier to get the permit changed. Whereas if they just decided, well, from a policy standpoint, we're going this direction instead of that direction, that would be a little iffier. Although, as Jeff said, there are very specific, very complicated exceptions and backsliding, which all of us have used from time to time, and we'd have to look carefully through them and figure out which ones might apply.
Yeah, Dave, before we move on, I think that question, to me, it crystallizes sort of this moment of opportunity we have and some of the resistance that you'll see at all the different levels. Because, you know, regardless of kind of where you stand on some of the policy questions, there a lot of the things that have always been just put out as like, no, we can't do that, I think are now coming into question. And you know, we'll hear if there are some positive changes from you know, discharge's point of view that can occur because of some of these changes we're seeing in the court cases. Some things that you know have at least certain discharges, I'm speaking mostly from a municipal perspective, have thought we're just wasted money, you know, not doing the right thing. We could use our money better doing this thing, but you know, no, we can't do that because of X. No, we can't do that because of Y. So I think some of those kind of we can't do it because are coming into question. And so I think that's the anti-backsliding one is one of the always ones, like Jeff said. You know, you ever want to make a positive change? No, we can't do it. You know, we all agree that it would be great, but hey, our hands are tied. So I think that, you know, some of the good coming out of this is opportunities to have more realistic discussions about what can be done and what should be done, and not just get sort of these legal answers of we can't do that because X, Y, and Z.
Excellent. I want to ask a couple of questions that have come in from the audience before we turn to our next group of cases. Does the logic behind the Loper Bright decision transfer at all to arguments by states about having to hew their decisions and actions in deference to EPA policy or guidance?
I would answer that maybe not exactly as the question was posed, but again, with the theme I just presented, I mean, I do think that these cases plus sort of some of the changes in the administration open opportunities for more positive dialogues about real solutions. Because at least in certain jurisdictions, I mean, Fred's talked about, you know, kind of the other extreme where, you know, states are prohibited by state law from going beyond federal law. There are states like California or other Western states that have gone way beyond federal law, in my view, and in the view of the court cases that some of which I've been involved in. But often that's been sort of under the auspices or like using EPA as they're telling us or they're pushing us in this direction. So I do think that, you know, there's, to the extent that these cases represent sort of a retrenchment and back to basics, what does the statute actually say, and not more than that, then I do think that will and could kind of filter down to those other states that sort of have historically used EPA as sort of a reason to push their envelope. So in that sense, I think it will have an impact.
Seth, I'm going to ask you, is there one more question from the audience that you'd like to pose right now? I think I'm going to skip the one you sent me. Any others that you want to bring up right now before we turn to the next section?
One question that came up is about the nature of the stormwater permitting program, that it's primarily regulated on single pollutants, primarily nutrients and sediments, but impacts are on aquatic life, use support. Basically, I think the question is there any push or any context that we want to look at these or can look at these rulings on that are more relevant to designated use that integrates chemical, physical, and biological integrity in a more kind of holistic way? This might be getting too much in the weeds on the technical side, but I don't know. I just wanted to throw this out there because this question did come in.
And we may want to talk about that a little bit in the context of the San Francisco case as well. But are there any
That's
immediate
good.
reactions, gentlemen?
Yeah, and that's
Well, I
good, Dave,
think-
because there was a question about making sure that we cover the San Francisco case. There's a lot of interest. Several questions have come in to make sure that we talk about that. So thank you, Dave.
Almost there. Any other reactions?
I would say that I do think that there's an opportunity. I think we saw this in the last Trump administration where they were more willing to let states do their own thing and not to veto state water quality standards, for example. So if a state say, and there have been some states who have shown interest in doing biological criteria, in focusing on sort of the overall state of the aquatic community instead of numeric standards, and EPA has been somewhat ambivalent on that. But if states want to do creative things like that, which we think they legally can do, and before they might have had some obstacles at EPA, there may be more opportunity at this point because this agency may be more receptive to letting states do things like that than they have been.
Okay, well, we're going to move along. Excuse me. To some of these other cases that I think might be germane to this discussion. And as I did before, I'm going to read a very quick summary of these three cases for those of you who maybe not.
Dave, you're muted.
Yep, always good at this. In this case, we're talking about the city and county of San Francisco versus EPA. In this case, San Francisco is challenging the inclusion of generic narrative provisions in its NPDES permit for combined sewer discharges. For example, the permit prohibits discharges that cause or contribute to violations of ocean water quality standards. The city argues that the permit does not include specific limitations on its discharge that the city can actually implement. The Ninth Circuit found that these generic narrative limitations are permissible. The case was argued before the court last fall and will be decided later this year. It raises interesting questions about the form of discharge limitations in stormwater permits and could affect how those limits are expressed in future permits. Another case, a little older, but is still out there and of interest, is a 2020 case, Maui County versus the Hawaii Wildlife Fund. And it addressed the question of whether NPDES permits are required for point source discharges that are conveyed to surface waters of the US through a non-point source. And in that case, it was through groundwater. So a subsurface discharge that reaches surface waters. It was a Maui County wastewater treatment plant that injected its treated effluent through injection wells, and then it was connected to nearby coastal surface waters. The court held that an NPDES permit is required for that facility, and held generally that a permit is required, an NPDES permit is required where there is a direct discharge or the quote functional equivalent of a direct discharge to jurisdictional waters. EPA began developing guidance to assist in interpreting this ruling, but didn't finish anything. And so states like Hawaii and others are continuing to think about what discharges that go to groundwater first might meet this functional equivalency court test that was set by the court. And that's of interest in a lot of places where people infiltrate stormwater. Last case, and a big can of worms to open, but we'll open it a little bit, is Sackett versus EPA. This 2023 case is the latest in a series of recent cases that address the definition of waters of the United States that are subject to Clean Water Act jurisdiction. This specific case addressed the question of whether a wetland owned by the Sackett family is a water of the US. And the court narrowed the definition of water of the US, holding that only those wetlands that have a continuous surface connection to adjacent navigable waters are waters of the US. EPA has not completed rulemakings or guidance to apply this ruling, and further work to revise the existing rules or the guidance appears likely. And this would certainly be of interest to stormwater managers, given the uncertainty about the scope of Clean Water Act jurisdiction in some urban waterway systems. So with that summary, Sean, I'll start with you and ask you, based on what you heard in the oral arguments before the court in the San Francisco case, what would you venture to guess how the court might rule?
Yeah, thanks, Dave. So I think, I mean, at least in my vote counting is pretty clear to me, at least, that there will be a reversal. So I think that that's, at least I'm pretty confident that that's the case. So the question is, how broad will the decision be? And that's where I think it's more complicated. You know, the one possible ruling, I think there was definitely some support from some of the justices, is basically to say, we don't find the authority for you to issue these kinds of catch-all generic provisions, you know, in the statute, and therefore you're not legally authorized to do that. I think there was, you know, some support for that, and I think some of the justices really got that argument. However, I think basically the solicitor gave an off-ramp that was pretty big for the court, which was basically to admit that there can't, these provisions, at least in those jurisdictions that use this type of approach, they're now in everything. I mean, in California, they're required to be in stormwater permits. So they're just, you know, you have all the other requirements, and then you have this overarching, essentially do no harm requirement. And I think that the government admitted to the Supreme Court that that type of blanket approach of having it in every permit is not consistent with the statutory language. And I think that the off-ramp that was provided is really two situations. One is when the discharger has failed to provide the information to the regulator, from which the regulator, you know, can derive more specific requirements. That may be one situation where a generic provision could exist. And then the other one is with general permits, because there was a lot of discussion about, you know, the general permit system is designed to, you know, have broad provisions to be something you can quickly obtain in the construction context, for example. And if we had to write specific provisions for each of those permits, it's going to grind that system to a halt. And so I do think that there's some, there was some receptiveness to the courts maybe having a more narrow decision consistent with that really sort of off-ramp that was provided. I think that it's going to be a little challenging, though, because you know, that this court is very much about what the text says, and I think it's, you know, it's sort of hard to have that kind of more practical result and still do a real textual analysis. And so I think that there's going to be a little bit of a quandary there. And I do think because of that, there's an outside risk that there's some even more narrow holding that, because, you know, San Francisco was very strategic in how they presented the question, and they really did put all their eggs in this one basket. So there was some discussion about, well, couldn't you still bring an arbitrary and capricious case? Do you have that right? So I'm a little worried that there might not be significant clarity coming out, but on balance, I think that there's going to be a reversal with a more narrow decision that at least cabins when you can have these kinds of provisions to certain limited exceptions. Oh, you're muted again, Dave.
Jeff and Fred, does that track with your thinking about the likely outcome? Seeing a nodding head, okay.
Yep.
Yeah, I think that, yeah, I think that both this in Maui County, sometimes problematic facts make bad law. And I think that, you know, I think it's very possible that what Sean said happens, which is the court feels like they need to narrow the EPA authority, but San Francisco might still lose because the court might say San Francisco, if the court finds San Francisco didn't provide all the information needed to develop numeric limits, then it could say it doesn't fit within that narrow exception. So, I mean, I do think the court's very concerned about the scope of EPA's narrative authority, which some of us have been raising for many years, that the narrative authority is really broad and that you should have numeric standards, and that the narratives have sort of been a crutch they've relied on. At the same time, I don't think the court, I think the court's concerned about going all the way the other direction and knocking them out entirely. But I agree with Sean that the problem is you start developing something in between, like, and where is that in the statute? You know, I thought the U.S. government's argument was actually pretty well crafted in terms of saying, hey, we're reading 301B1C of the Water Act. Where's the language that the city cites to? It's not really there. If you had a strict textual reading, the government might win. But the court doesn't want to go in that direction. So I do think they have a difficult decision, but I do think that it'll probably narrow at least somewhat the EPA's narrative authority.
Well, Jeff, I'll ask you, certainly chime in if you like, but just ask you more directly, do you think that likely decision would have specific implication for the structure of stormwater permits, which around the country have a really interesting mix of the way that limitations are expressed?
I do think that, you know, I'm nervous about where the court may go on this, both to these kind of generic backstop provisions, as well as the impact that this is going to have on the permit shield. But I want to take a step back and say we were in a similar situation many years ago with the Entergy case, which was a cooling water intake case, which basically the courts were trying to interpret the definition of best technology available, which is what's applied to cooling water intake, as opposed to best available technology, which is NPDES permits. And my large construction trade associations got very nervous about what the court might decide there and how it might impact interpretation of applying costs to technology standards within the Clean Water Act. So we actually drafted an amicus brief outlining all the different technology standards and how costs could be used. And we're flattered that the Supreme Court relied on a lot of that in their decision on that. And the real goal was, we hope that the court doesn't mess up the Clean Water Act. We might argue that, you know, from Rapanos to Maui, that, you know, when you ask them to make these decisions and they get off the tracks, that it's kind of crazy. So same groups filed an amicus brief in this case to basically kind of inform the court that, yes, narrative standards can be very important in the stormwater world, particularly in general permits. And we rely on them, but we rely on them mostly to satisfy the technology-based requirements of the permit. We identify technologies that can be implemented, we describe them, we put them in stormwater pollution prevention plans or municipal plans. When it gets to water quality standards, again, I go back to the fact that, you know, we're trying to put this square peg in a round hole. But generally, in different litigation we've been involved with, whether it was in Region 1 for the Massachusetts and New Hampshire small municipal permits, we very clearly define those kind of narrative technology-based standards and the presumption that if you do these and do these things correctly, you will be presumed to comply with water quality standards unless somebody can demonstrate otherwise, in which case you have to go back and revise your plan. And I think that's the process that we want to see here. So again, we filed an amicus brief to identify the importance of certain narrative standards, effluent limitations within the stormwater permitting program, so that we don't get this kind of all or nothing that could happen as a result of what was being argued in the Supreme Court. And then again, just we're very concerned that the continuing eroding of the permit shield. I mean, the idea of the permit shield was you informed, as Fred indicated and Sean, you inform the regulator everything that's going on. You get a permit, and you may have a permit with numeric limits for indicator parameters or other things. But if there's no specific limit for an activity or pollutant you identified to the regulator, it's assumed that the other technologies would also treat that pollutant, and that's an important shield. I think we're eroding that shield quickly when we start talking about, some of these narrative standards that, if you discharge, if there were limits on, say, turbidity, but then there was, and you met those, but then there was also cannot cause or contribute to, and to a water impaired for sediment, then technically those are working in opposite ways there. So, I think those are the concerns that we have, and we're hoping that the court will take a very close, hard look at the implications of their decision across the NPDES permit program.
Yeah, Dave, can I jump in? Because I think that's a critical point, and I think some of the questions that you're seeing coming in are on this point exactly. That, I mean, people want to look at this as like either you have no narratives, or you can have narrative. That's not the question. I mean, the ill here really is somewhat more specific to the type of blanket water quality based catch-all generic provisions to, like, essentially don't ever cause any harm or don't ever contribute to any harm, because it's really the contribute that's the problem, right? And I mean, that's what is teed up, but the problem is it's gotten kind of caught up with all these other discussions. And I've talked to many regulators who are essentially like, why would you ever ask for that? Because now we're just going to give you all numerics. Well, that's not what is being asked. I mean, what is being asked is exactly what Jeff says. If you can have a narrative limit that is specific that you can implement, and if you implement, it should have this desired result, and that should be compliance, and that's it. That's a good thing, and no one's asking the court to change that process. But what isn't a good thing is you do everything specific in your permit, and there's still a problem in your receiving water, and somehow you're on the hook. That's not fair, and it erodes, as Jeff said, the permit shield. So, whether any of that got across to the United States Supreme Court is a huge open question. And I think I said this, Dave, at the presentation you mentioned earlier, that it was the first time in my life that I've ever listened to a Supreme Court argument and felt smarter than the people there, just because I know this. And there were justices who clearly had no clue they didn't understand the difference between a general and a specific permit or narrative. And obviously they're still going to figure it out, and they're smart, and they got a lot of smart people working for them. But I am concerned for all the reasons Jeff said. I think Jeff really articulated that well.
Jeff, back to you.
I think the other thing that this points out is in my mind, kind of, and not to offend permit writers, but sometimes it's lazy permit writing. They're worried that they haven't done enough, so they throw in these backstop type provisions, when in fact, if they really went through and drafted a very complete permit, they wouldn't need these. They'd realize they don't need these. And I would point again to the Massachusetts small MS4 litigation, where that language was in the permit. We challenged it. And the solution and settlement, including with the NGOs, was, hey, let's put together a permit that really defines for the municipality what it needs to do. It may not be easy. And then we're going to presume that they're going to meet water quality standards. And if there's evidence that there is a particular problem from a municipal discharge, then we can go back and take a look at how to do that. But we're not going to put in a bunch of generic provisions that give people citizen suit authority to challenge that municipality. It's going to be done through a regulatory process, not a litigation process. And I think that's the right solution. And I think we're getting there in the stormwater world, but more work needs to be done.
Fred? You're on mute.
I would just add, it goes back to one of Sean's point, is in other contexts, to the extent that this sort of issue is ballooned, it poses concerns in other areas like nutrients, where we don't want numeric standards for nutrients. We want to be able to look at the weight of the evidence biologically. And so there are other situations, particularly say for POTWs on nutrient issues, where we've said, look, we really don't want numeric standards because they tend to get driven down to incredibly low levels based on a very narrow look at phosphorus or nitrogen. We'd much rather be able to look at other stressors, whether it's dams or other habitat modification issues, etc. And narratives actually give us some flexibility to do that. So there are some areas where we really like to sort of retain a focus on using narratives because they're flexible, and instead of a very narrow focus on one pollutant or another. And you know, it would, the one concern is, will the court's ruling touch way beyond the limited situation in San Francisco and affect potentially some flexibility that we really like?
I want to pick up on a couple of audience questions, and then we're going to leave this one, but it concerns the MEP standard, maximum extent practicable. And people are just interested in your thoughts about whether a ruling in the San Francisco case, you know, how it might fit with the ongoing use of the MEP standard and its application in stormwater permits. Any thoughts there? Sean, maybe I'll start with you.
Yeah, I think kind of we've touched on this already. I mean, I don't think that there's any inconsistencies, and at least if the court is understanding the arguments as Fred and Jeff and I have tried to articulate them, because I think I think the use of these generic provisions is a significant problem and is inconsistent with the MEP standard in my view. But use of narrative provisions written properly based upon a full, you know, submittal and with rigor is entirely consistent with MEP. So I don't see this as any problem in terms of fit, depending upon, of course, how the court rules. And if it takes, you know, more of an extreme view, then yeah, there could be some challenges there. But if the argument is understood correctly, and you know, if the proper use of narratives, which have a critically important role, particularly in stormwater, I don't think there's any inconsistencies at all.
Fair enough. Our time is running short, so we're going to move on here a little bit, and we'll go over to Maui County for a minute. Jeff, do you see that there are going to be implications for stormwater permitting a result of this requirement for some subsurface discharges to be regulated through NPDES?
Absolutely. I mean, you know, I think what has been lost in the Maui County decision and subsequent guidance is the fact that we still need the basics to require an NPDES permit, and that is a discharge of a pollutant from a point source to a water of the U.S. And whether the Maui County injection well was really a point source or not was never even litigated. It wasn't briefed, it wasn't argued. So, you know, we're kind of starting in Maui County with this assumption that everything is a point source, and that's just not really true. I mean, if you look at stormwater infiltration technologies, you know, I would argue those are not necessarily point source discharges. I mean, the most simplistic is kind of looking at septic systems. Are we going to regulate and now permit every septic system under an NPDES permit? I don't think we are going to do that or need to do that. So I think that there are a variety of tools and technologies available that allow for us to treat stormwater without it ever being discharged, quote unquote, through a point source. And so that's my concern with how they do this. When in the Maui guidance that was put out by the Biden administration, you know, the flow of the groundwater was determined in part to be what was moving the pollutants and responsible for moving the pollutants. And again, that's very different than a point source discharge to a water of the United States, even through something else. So I have some real concerns about Maui. I had some concerns when I read the opinion after it came out, because I looked at that opinion as kind of a crazy Supreme Court theory that they came up with and these different factors. I think going back, it's one of those cases where Maui County had bad facts to begin with, and those facts were not clearly kind of dissected and put back together in a more reasonable way than what we got. So I'm concerned about Maui County for as long as it it stays kind of on the books, and we'll see what the Trump administration does in terms of revising guidance, going back to its prior guidance, which was about, I thought, as clear and capable as you could do with the Supreme Court decision.
Right, Sean, want to weigh in? Want to move on?
Yeah, I'll just say that Justice Breyer wrote the opinion in Maui County, and it was very much like the administrative law class I had with him. He liked to make very clear, like, little distinctions. The implications he clearly left for others. And I think we're still trying to think through what the implications are, including, and I think this really was something that EPA has punted on, and we've said they shouldn't punt on, is there are some situations that clearly will meet the test. What are those? How do you apply? What does the permit application even look like? Because it's got to be different than for a regular discharge. And what does the permit look like? Where do you monitor? Where do you determine reasonable potential? How do you regulate here? The court clearly said, we're not getting into that. We'll leave that to EPA. And so far, EPA hasn't really done that. Dave, I know this is an issue you're involved in trying to think through what the implications are of that. And I think that's an issue that over the next few years, we're going to start dealing with some examples and try to figure out sort of how do we address this.
Great. The next question I'm going to throw out to all three of you, and we could go down a big rabbit hole on this, but it's on waters of the U.S. And I'll just ask the question this way. Do we think that this collection of recent Supreme Court cases on waters of the U.S. will prompt changes in how stormwater discharges are regulated under NPDES? I guess I'll also ask the question, do we think there'll be more rulemaking or guidance out of the new administration to address this new law?
I think there will be, I'll start on that particular issue is, I do think there will be further action. The interesting question is, will that be rulemaking or guidance, or maybe both? I mean, we know from Sackett and from the rule that followed from Sackett that jurisdiction's a lot narrower now. No one's really sure how much narrower. That's really unclear. And we have seen some attempts by EPA and the Corps to sort of stretch the boundaries of that since Sackett in terms of decisions they've issued. I do think that's gonna get cut back. Now, that might be through guidance, maybe instead of a new rule, because new rule we're gonna get into litigation again. Some of us think maybe guidance is a first step in trying to clarify some things and making sure that the rules and guidance together sort of follow the lines established by Sackett, which are narrow, because right now that's unclear.
Sean, Jeff, anything you care to add?
I would just add that it's very clear from the first month plus of this administration that they're going to shrink the size of the federal government, and they're going to push more responsibility down to the states. I think that's really what Sackett is about anyway, was what is subject to federal jurisdiction and what should be subject to state jurisdiction. And I think there's going to be a lot more pressure on states to develop their own clean water programs to kind of pick up the pieces from Sackett and have a more federal approach to clean water. I understand the original approach and the fact that there were concerns that states would race to the bottom. We're not there anymore. So I think that states have unique and different water resource issues and just the whole nature of what weather is across the country. So I think that we're going to look at probably a very solid federal based foundation that states will then build on.
Yeah, I agree. I think that's the action is really going to be at that, how much states backfill, right? That's going to be, and you're going to have certain states that are very aggressive and other states that may not be as aggressive, and that will be an interesting process.
Great. All right. Well, let's move on a little bit and guess a little bit of future and what the new administration really does want.
You went on mute again, Dave. Yeah.
You're muted again.
Yes, indeed. Thank you. I'm going to ask each of you to opine for just a minute or two on given, you know, what we've seen from the courts, but also the little bit that we've heard about some of the priorities of the new administration. And I summarized those in this slide for your consideration.
You're muted again, Dave.
And you're muted again.
I'm having a day. I'm sorry, folks. Focus of the new administrator: clean air, land, and water, American energy dominance, permitting reform and cooperative federalism, U.S. dominance in artificial intelligence, and American auto jobs. And then, oh, by the way, there's some interest in budget and staffing reductions. So I'm going to ask each of you, if you could, to just take a minute and talk about how and whether and how you think they are going to take actions that are going to change how stormwater permitting proceeds. We've already.
I'll start.
Keep going. Yeah.
I'll start by just saying that, you know, obviously we've learned in the last 40 days or whatever that things are entirely unpredictable sometimes. If you look back at the last Trump administration, you know, I would have argued that the multi-sector general stormwater permit up through about 2015 was an efficient, effective permit that had balance and everything else in it. The Trump administration promulgated the last MSGP, and I'd argue they ruined it in a lot of ways. And part of that was because leadership was so focused on the waters of the United States issue that they didn't focus on other, what I consider very important issues. And so we have to see if that's going to happen again. I mean, you say the Trump administration may fix things, but they also get very dialed in on certain things and then kind of ignore other things to people's detriment. So I think the challenge is going to be for those of us in this arena to be identifying the key kind of issues, both that are working effectively now, and then others that may need to be fixed to work more effectively in the future. And we're going to have to be the advocates for those at whatever is left of the EPA when this whole process is done with. So I think those are our challenges. I think you can, you know, you always have to look at these things as opportunities. I know it can be depressing at times to read the news, but I think you have to look at it as opportunities to really kind of put together the best programs we think would work, from municipal stormwater, industrial stormwater, whatever, and advocate for those while there's kind of this state of flux. So we need to just be nimble and focused on those issues.
Sean, could I ask you to go next?
Yeah, absolutely. And I would start with where Jeff ended. I 100% agree with that. That's the opportunity component of what's there is critical. There's going to be so much uncertainty, and if you just try to swing back and forth, you know, from administration to administration, it's just going to be a problem. I do think we're at this moment where, you know, as Jeff just said, we can try to find the best programs that really work, and really maybe we have an opportunity to sort of get those in place. And yeah, you could sort of race to the bottom, but you could also be an advocate and find something that works and land somewhere that could be more sustainable. So that's how I'm glad, Jeff, you said that, because I 100% agree with that. I do a couple other real quick points, Dave. I do think that the San Francisco case in a short term could be a massive change depending upon what the decision is. If it is, you know, sort of what San Francisco is asking them to do, that is going to be a massive change in permit writing. And then in terms of just, you know, the federalism issues, I think we're absolutely see the retrenchment at the federal level, state backfill. I think we'll see, and I've already seen, significantly more citizen suits, you know, NGO activity to try to push back on some of these changes. So I do think it's going to be an interesting 4 years. But I just would reiterate what Jeff said, which is, you know, let's see this as an opportunity and get to a place where we can have good, solid programs that are sustainable and, you know, kind of can last across administrations.
Brett?
Yeah, I agree with what the other folks have said. I think that it is really hard to predict where things are going to go from day to day. And I think the staffing and budget reductions will have a significant impact on the functioning of the agency. And one can argue if that's good or bad, but I think it's going to be a different EPA. But I think that doesn't mean you can just sort of sit back. To me, there are two aspects of that sort of motivate toward action. One is then we need to figure out what we want them to do and not do, and tell them, hey, here's what we think the permit ought to look like. Here's what we think your regulatory scheme ought to look like. We can work with you to help make good things happen, more effective things happen, more efficient things happen. The second aspect is, I absolutely agree with Sean that states are already taken this as a signal they need to ramp up their programs. I was certainly seeing that on PFAS, for example, where states are saying, well, if the EPA is not going to act, then we are. And whereas I think they sort of, for a second, took a breath and thought that maybe there was more action at the federal level. Now, if they see, whether they perceive it, they perceive less federal action, then they're likely to ramp up their efforts. NGOs possibly as well, although I haven't really seen as much of that as I would have expected. That may be coming too. So, we can't just say, well, people said to me, oh, you're not going to be very busy. And I said, no, I think we'll be plenty busy because not only federal action, but state action, NGO suits, et cetera, are going to be out there and probably at an increased level.
Good thoughts. I'll ask one final question and then we're going to wrap up. If there is this push through cooperative federalism to push more of kind of the responsibility and authority back to the state level, do you think that you're going to see states diverge even more than they are divergent now in terms of sort of the stringency and the detail in their stormwater permitting programs? Or are things going to happen that will lead them to sort of come more together and become more consistent with each other in the near future? Any thoughts on that?
I think the states are pretty coordinated through the Environmental Council of States and others. I think that, I think they look to each other to figure out what's working well and then try to copy that. So I don't see them necessarily becoming more divergent. You're always going to have the California, Washington, New Jersey, approach versus the, let's just say Texas, Wyoming approach. I don't know, but I don't think it's going to be that significant. I think everybody, I've never talked to anybody that doesn't want clean water, land, or air. So, I think we're all in it together. The question is, what's the best way to get there?
Sean, Fred, anything you'd like to add?
Well, yeah, I mean, practicing more in those more extreme states, I guess I have a little bit of a bigger concern of a gap growing, but I do think Jeff's right. I mean, at some level, we're working with the same law and, we're working across similar goals. I do think at least initially in those states that have traditionally been more aggressive in pushing additional restrictions, I think we're going to see a little bit of doubling down on that. But I think realistically, that's going to have to come back at some point in time because it just, I mean, even if you just think about the resources and the resources required to sort of sustain that kind of a program, I think that's going to be a problem. So maybe I'll take some optimism from Jeff's comments.
Yeah, sure. Some of the states, well, I mean, we practice all over the country, but both in states that are more restrictive and some that cannot be more restrictive. And there, I do think there's going to be a real narrowing in those states that are limited, that cannot be more restrictive than the feds. And I also think it's important that what we're seeing is legislatures saying, no, here's what you're going to do, responding to political pressure and in imposing more restrictions, and also attorneys general being very active, particularly the Democratic attorneys general. And sometimes there are fights between the Republican and the Democratic AG groups. And I see that continuing in terms of those actors, not even the environmental agencies, but legislatures and AGs pushing one way or the other. And so I see that potential for conflict going forward.
Thanks very much to the three of you. Thank you to the audience. I'd like to turn it over to Seth to have the last word.
Yeah, again, I also want to thank Jeff and Sean and Fred for providing this great input. We've had 300 attendees. Almost everybody stayed till the very end. So clearly it shows a high level of interest, tons of questions, and we couldn't get to all the questions. We'll try to get follow up on those in a written form if we can do so. And thank you, Dave, for organizing this. Greatly appreciate that. And we will, you'll be, those who have attended this, you'll be receiving a certificate. There'll also be a link to the recording on our YouTube page. So check that out. And clearly there's a lot going on. There's a high degree of interest. There's a lot of dynamics going on here with this Supreme Court and the current administration. NMSA will definitely stay on top of this, and we'll work to provide you with information as much as we can through events like this. So again, we appreciate everyone joining us, appreciate the panelists, and appreciate Dave. So thank you and have a great day.
Thank you.
Thanks, everybody.
Thanks.